ಅವ್ರು ಬರಲ್ವಾ?
ಕಾಣಿಸ್ತಾರೆ, ಸೇಮ್ ಕಾಣಿಸ್ತಾರೆ, ಬಟ್ ತಮಗೆ ಇದಾಗೋದಕ್ಕೆ ಕಾಣುತ್ತೆ.
Yes, 20.
Your Lordship, I am the proxy counsel for the petitioner. The main counsel is in personal difficulty, Your Lordship. So I am requesting Your Lordship kindly put the matter for any other day in this month, Your Lordship. As
This matter is of the year 2016.
Yes, Your Lordship.
You want adjournment yet?
Actually, Your Lordship, as per the last date, Your Lordship, the matter is fixed within 4 weeks. So right now the main counsel is in traveling, Your Lordship. So he couldn't appear today, Your Lordship.
Okay, what is this matter, Mr.
Disposal of iron.
Repeat ಮಾಡೋಣ ಆಮೇಲೆ ನೋಡೋಣ. Counsel for the petitioner, prays for time. Prasanna Kumar for respondent 2 is present. Just next week.
Any other day, Your Lordship, except 23rd of February, 24th of February, Your Lordship. Any other day.
To 20, except 24th.
Yes, Your Lordship, except 24th.
Just any day except 24th February. Yes.
Much obliged, Your Lordship. Much obliged.
Lakshmikant. Counsel for the petitioner.
Appear for the respondent in this matter, my lord. They have not been appearing since a long time.
For the petitioner, Mela.
Yes.
Mela, the proceedings may not initiated and only 138 of Act.
Yes. Yes, Mr. Lakshmikant.
My lord, the main ground, my lord, that my lord, the check-in question has not issued in favor of the accused.
Check-in?
My lord.
Yes.
Check-in question is not issued in favor of the complainant, my lord. And it was issued in favor of one Anmaya, my lord. My lord, since there was this criminal dispute pending against the complainant as well as Anmaya, my lord, for taking such revenge, my lord, yes, the check has been collected from one Anumaya, and the present check has been case is registered, my lord. And apart from that, my lord, the notice, my lord, is not served on the accused, my lord. As per the Shara, my lord, at the time of the, because of the complaint as well as the accused are the none other than the relatives, my lord. The Shara, my lord, which clearly shows that, my lord, the notice is not served on the accused, my lord, which is mandatory requirement, my lord. In the evidence also, my lord, yes, admitted.
What is the finding of the trial court on service of notice, about service of notice?
Not to the finding, my lord, the under certificate of posting, which is believed, my lord. The certificate posting, my lord, is, my lord, UCP. That, my lord, was issued to the same address, my lord. When the postal authority have issued a Shara in the
Yes, sir. Exhibit P1. Check.
Page number 12 of the judgment of the lower court, my lord. It has been clearly mentioned that the issue has been framed.
The check is drawn in the name of B. Shivarajaya, the complainant.
The contention of the petitioner is that, my lord, Anumaya, who is the brother of the complainant, they state that he was running a chit fund, and because of that, the check has been given as a security.
Your address is correct, Raju HB.
My lord,
whether the address is correct?
My lord, he was not staying in Bangalore, my lord.
Huh?
At the particular time, my lord, admittedly he was staying in Bangalore since from 10 to 13 years, my lord, which is admitted by the complainant during the cross examination, my lord.
Where is the admission? Please show.
My lord, page 5 of the cross examination, my lord. Second para. ನಾನು ಶ್ರೀನಿವಾಸ ನಗರದಲ್ಲಿ
Wait for. Cross examination. You are reading cross examination.
ಪ್ಲೀಸ್ ಯುವರ್ ಆನರ್. ಫಸ್ಟ್ ಲೈನ್ ಮಾಡಿ. ನಾನು ಆರೋಪಿ ಒಂದೇ ಊರಿನವರು, ನಾವು ಅಣ್ಣ ತಮ್ಮಂದಿರು. ನಾನು ಬೆಂಗಳೂರಿನಲ್ಲಿ ಶ್ರೀನಿವಾಸ ನಗರದಲ್ಲಿ ಕಳೆದ 15 ವರ್ಷಗಳಿಂದ ವಾಸವಿದ್ದೇನೆ. ಆರೋಪಿಯು ಬೆಂಗಳೂರಿನಲ್ಲಿ ಆಟೋ ಚಾಲಕರಾಗಿದ್ದಾರೆ. ಆರೋಪಿ ಕಳೆದ 10 ವರ್ಷಗಳಿಂದ ಆಟೋ ಓಡಿಸಿಕೊಂಡು ಬೆಂಗಳೂರಿನಲ್ಲಿ ಇದ್ದಾರೆ. ನಾನು ಶ್ರೀನಿವಾಸ ನಗರದಲ್ಲಿ ಇದ್ದು, ಆರೋಪಿ ಶ್ರೀನಿವಾಸ ನಗರದ ಪಟೇಲರ ಪಾಳ್ಯದಲ್ಲಿ ವಾಸವಾಗಿದ್ದರು. ಆರೋಪಿ ಮತ್ತು ನನ್ನ ನಡುವೆ ಪರಸ್ಪರ ಹಣ ಕೊಡುವ ಮತ್ತು ವ್ಯವಹಾರ ಮಾಡುತ್ತಾ ಇದ್ದೆವು. This matter. He was very well known that matter. The accused was staying at in Bangalore matter, and the notice was sent to the at village address matter. The Sharai also, my lord, which clearly reflect.
What is your suggestion? Please read. RPAD ಮುಖಾಂತರ ಕಳುಹಿಸಿದ ನೋಟಿಸ್ ಜಾರಿಯಾಗಿದೆ ಅಂದ್ರೆ ಸರಿಯಲ್ಲ. You have given a suggestion admitting.
My lord, ಸರಿಯಾಗಿಲ್ಲ ಅಂತ ಬರ್ಕೊಂಡಿದ್ರೆ that it was written, my lord, by oversight it was written. ನೋಟಿಸ್ ಸರಿಯಾಗಿಲ್ಲ, ಜಾರಿಯಾಗಿಲ್ಲ ಅಂದ್ರೆ ಸರಿಯಲ್ಲ ಅನ್ನೋದನ್ನ ಕೈಪಕ್ಕದಲ್ಲಿ ಎರರ್.
Your suggestion itself shows that notice was served on him.
My lord, the suggestion was that, my lord, it was a typographical mistake, my lord. Notice ನೀವು RPAD ಕಳಿಸಿದ ನೋಟಿಸ್ ಜಾರಿಯಾಗಿಲ್ಲ ಅಂತ ಕೇಳಿದ್ದಾರೆ. Exhibit, my lord.
Yes, notice is not. Heard the petition's counsel is admitted. Yes.
Without touching the merits of the case, my lord.
You are for the respondent.
This was, I had to pay 1,25,000 balance. So on the 2 installments ಕೊಟ್ರೆ 2 ಸತಿ ಬರ್ತಾನೆ ಇಲ್ಲ. Already deposited 1 lakh. So 1,25,000 I have to pay, my lord. So ಮೇಲೆ ಒಂದು installment ಒಂದು ಆಗಸ್ಟ್ ಮೇಲೆ ಕೊಟ್ರೆ.
ನಾನೇನ್ ಕೊಡಕ್ಕಾಗತ್ರಿ, ಅವ್ರು ಬರ್ಬೇಕಲ್ಲ.
Because he normally practices in transport. I told many times.
He comes and I can ಮಾಡಿದ್ರೆ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ಜಾಯಿಂಟ್ ಮೆಮೊ ಹಾಕಿದ್ರೆ I can pass an order.
Dispose ಮಾಡಿ. So he's a director because of this corona. He's a noted director. The Kourthall Ramkrishna, he has directed many movies. So because of film land, theaters are not allowed for full capacity.
It'll be formula. I will admit. I will admit. Let him come any day.
Admit, Swami. Please.
Yes. Kumar. The order sheet shows that the petitioner's counsel has been absent continuously. Today also the counsel for the petitioner is absent. Since the matter is not yet admitted, submission petition is discussed for non-prosecution. Yes.
$27, my lord.
Yes, 27.
I'm for the respondent, my lord.
Huh?
I'm for the respondent, my lord.
All right, I will hear you.
Please, my lord.
Petitioner not complied the condition of deposit for suspending the sentence. So 5 days will not, otherwise I'll go on. 5 days will not, I'll he assured to deposit.
I will vacate the interim order.
In 5 days, he assured to upload in 5 days. Otherwise, will not happen. Only 5 days.
One 38, huh?
Yes, yes, my lord.
He says that within 5 days, he will deposit.
He told me that we'll arrange the entire 50% of amount as ordered.
Lord, they have not
Triangle suspect.
complied. It's admitted liability, my lord. The amount has been transferred by
You settle the matter. Settle the matter once for all.
I'll make efforts. 5 days time, Lord, I'll come with the question.
Counsel for the petitioner prays for time, saying that if 5 days time is granted, petitioner will will try to settle the matter with the respondent. Counsel for respondent is present. Therefore, list after a week.
My lord, a date may fix, my lord.
25 to list.
Please, my lord.
28 to.
Oblige, my lord. Connected matter, my lord.
Yes. ಎರಡು ಒಟ್ಟಿಗೆ ಮಾಡಿ.
Oblige.
My lords, I appear for the petitioner. I
I'm
seek
for the
some time
respondent,
to
my lord.
address my arguments on the admission.
Who is for petitioner?
I
Manjunath
seek some
RP?
time to address my arguments on the admission.
Why?
Please, I appear for the petitioner, my lords.
Why do you want time?
My lords.
Why do you want
I
time?
sought accommodation. I was not in the town. I was not in town, my lords. I just reached Bangalore today. I need an accommodation. I would address my arguments on the next date of
The
hearing.
sentence is suspended.
Please, my lords, may it be the next week, my lords.
You don't
Once
argue,
I've
I will
complied the
vacate the interim
please,
order.
I would address my lords. I would address my arguments on the next week, my lords.
There are two other connected matters between the same parties.
Give the numbers.
Criminal revision petition 45/2020 and 53/2020. my lord. All the three may kindly be connected. my lord.
Counsel for the petitioner prays for time to argue on admission. Start making it clear that if he fails to argue on the next date for admission, petition will be dismissed, adjournment is granted. Stop. Next para. Now that counsel for the respondent submits that criminal revision petitions 45 of 2020 and 53 of 2020 are connected matters. Full stop. Therefore, the registry is directed to list all these three cases together. Yes. It's next week. Yes.
Much obliged.
I appear for the petitioner, my lord. I have advised my
Yes.
client to settle the matter. Therefore, 2 weeks time may be granted. We will report settlement.
Settlement. He is proposing settlement. Yes. Counsel for the petitioner proposes settlement. Full stop. Respondent's counsel is present and submits that she will consult her client. When do you settle, Mr. Ganesh?
Or 2 weeks time may be within that we will report.
Therefore, 2 weeks time is granted. Yes.
Obligement.
Shankar HS. Shankar, counsel for the petitioner is absent. List out for 2 weeks. Raj Ballard. Same. Yes.
Last occasion. Concurrent and 4,28,000. The last occasion, there are no recommendation. Therefore, I will vacate the interim order so that I can execute that. Is given an undertaking before the police and given a check, and in case if it is a check become dishonor, he is ready to pay the interest also.
That
was
means
the
you
undertaking.
obtained the check in the police station by putting threat.
That I-
138, how can you prosecute under section 138?
So avoid that
Huh?
circumstance case. He is from Orissa state. He has constructed the 12 plots by the appellant. He has executed the work of plumbing work. At that time, for the purpose of allotment of the rental of, he paid them. Subsequently, he turned up. Thereafter, he has postponing. He is a leader in the locality. To avoid the atrocity case, I give him the police complaint. The police was called for an inquiry. He is a casual laborer, plumber. He has given an undertaking that he is issued a check and request him to present as such and such a check. In the event if it is become dishonor, he is ready to pay the interest also. That is the statement made. That it is admitted by him that regarding the execution of the work and that the payment received by him. Loan ತಗೊಂಡಿದ್ದೆ 1,00,000 ರೂಪಾಯಿ ವಾಪಸ್ ಕೊಟ್ಟೆ ಚೆಕ್ ಇದು ಮಿಸ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. That is a Orissa state, you don't know the language also. This is what it is concurrently held that.
Has he deposited any amount?
2 lakhs he has deposited by virtue of the interim order granted by the Honorable Court. That I have withdrawn. The Honorable Court also permitted me to withdraw.
What is the check amount?
That 4,28,000.
Fine amount?
Fine amount that 20,000. Payable to the government.
Conviction ಎಷ್ಟಾಗಿದೆ?
Separate court ಅಲ್ಲಿ modify ಮಾಡಿ.
4,44,40. Trial court imposed sentence of fine of 4,40,000. The appeal, what happened?
Appeal modified only to the extent of that the
4,28,000.
1 year punishment that was modified, restricting to 3 months. The amount is the same.
Counsel for the petitioner is absent today also. Counsel for respondent is present. Is present and submits that. The respondent has already withdrawn 2 lakhs.
Yes.
2 lakhs deposited by the petitioner. And that the interim order granted by this court be vacated so that the respondent can enforce the sentence imposed the petitioner. Taking note of the conduct of the petitioner, petitioner's counsel in remaining absent continuously, without arguing for admission, the interim order granted on 6/8/2020 is vacated. Yes, list after 2 weeks.
34 Sumati, yes.
Sumati, yes. Counsel for the petitioner is absent. Date court list after 2 weeks. Prakashyam. Prakashyam.
Sorry for the interruption, my lords. Serial number 36, I appear for the respondent number 123.
That is adjourned in the morning itself. First.
Sorry, my lords. No
Adjourned by 1 week.
Very well. No
No,
intimation was given.
since the counsel for the petitioner wanted time, it was adjourned. Yes.
Very short question of law is involved. I shall take
All
my
right.
chance during the next.
We'll see next time. Yes.
Very well. I'm grateful.
37. Counsel for the petitioner is absent. List of 2 weeks.
38.
On filing of memo of calculation of arrears of maintenance. Same. Vinod Kumar. Varatana. Yes. Also for the petitioner and the responder are absent. Please stop for 2 weeks.
Lordship, this Honorable Court has disposed the matter of two accused by the judgment dated 22/2021. Criminal petition, Manjur mentioned of 2021.
You know what?
Does it way this petition also may be disposed the same ground? The lot that
Can you be slow?
He's not a first time offender. It's an habitual offender. There was one more case where we got a legal argument. Legal offense has been committed by petitioner.
You are now convicted for what offense?
380 and this matter. In this matter, you have been convicted.
380.
380.
And
Earlier also 380, wherein he got a acquittal order. Sure that he is an habitual offender. It's not.
Is it discussed about that he is an
Other body also. May read the judgment. It's on the report. Page number 19.
This one? Ida?
Page number 19. Applying the set principles enunciated in the above decisions to the case on hand, the trial magistrate ought to have taken note of that the accused is the first time offender and in the absence of any previous criminal actions with regard to the accused, the trial magistrate ought to have granted probation to the accused. Unfortunately, the learned judge in the first appeal court has also failed to do so and to do so. Accordingly, this court is of the considered opinion that if the accused is deliberately excluded personal policy for example, satisfaction by the trial court for his good behavior. Yeah, he's not the first time offender.
He was released on probation. No? The same accused is involved.
no, Your Lordship, same offense, Your Lordship. Here, co-accused was released on probation. As far as his first accused, Your Lordship.
He is not the first time offender. This accused, Basuraju.
Why are you referring to this judgment?
Same offense, Your Lordship. The same offense. Both were accused, Your Lordship. So in this one, they have left him on probation. 66 was the case, Your Lordship. I see page number 28, Your Lordship.
The argument CC 366 of 2012. The absolutely correct in this then some for the first time.
There are two accused. There are two accused. One accused is released on probation, and this petitioner he claims the same penalty.
He's involved in another case wherein he got a acquittal. It shows that
Is it on record to show that he was involved in the other case?
Police don't put in. It's a reference. First case he got acquittal order.
This accused Hanumanta, first accused Hanumanta, second accused Hanumanta was acquitted by this, at least on probation.
Yes.
Alva. Conviction is not set aside.
No.
Was released on probation. You want the same benefit.
First time offender.
So far as the petitioner is concerned, he is not the first time offender. That is your submission. But this second accused is not so. Second accused who is the first time offender. That is what is held here.
First time offender allantane kotirodu. Adu vere
What sheet code?
Your Lordship, can you see page number 10, Your Lordship? In that page, paragraph 14 in the judgment.
Yes. Really? You are involved in another case, Mr. Sachin. You are involved in another case, already involved in another case. Then how can you claim benefit under Probation of Offenders Act? Please argue. Please argue. What is there? Come on, argue now itself. Case of 380 theft. Is there recovery? Is there recovery?
Recovery is happened at the instance of the accused person.
Theft case Indian bakery. Recovery is the main ground.
And it is,
See, the very fact that this court has not set aside the conviction in this case, I can follow this, shows that. Barcode. Sri Sachin, what's your name? Huh? Sri Muhyiddin Arafat for Sachin BS, appearing for the petitioner. Stop. Government pleader also. Next para. The petitioner is accused number CC 366 of 2012 on the file of civil judge and JMFC, additional civil judge and JMFC. Stop. The petitioner and other accused, namely Hanumanta, were tried for the offences section 457 and 380 IPC. And convicted and sentenced. Stop. Aggrieved by the judgment. Of conviction. The petitioner preferred approach the district and sessions court Chikmagalur by filing criminal appeal 20 of 19. Stop. The sessions court of reappreciating the evidence, confirm the judgment of the trial court and dismiss the appeal. And hence this revision petition by the petitioner. Stop. Learned counsel for the petitioner submits that accused number 2, Hanumanta, also preferred an appeal 195 of 19 before the sessions court Chikmagalur, and his appeal was also dismissed. Stop. He then approached this court by filing a criminal revision petition 1097 of 2021. Stop. This court, while this court passed a judgment on 22nd December 2021, giving benefit under the Probation of Offenders Act. Therefore, it is a submission that since the accused has been released on probation, the same benefit be given to the petitioner hearing. Full stop. He also submits that even otherwise, there are good grounds to set aside the judgment of conviction. Here, what is your ground for setting aside? Next date Kodala, simple matter. I don't give time. What is the main ground you have taken? Please tell.
Your Worship, the Mahaja witness in one of the cases, in the previous case which he has quoted, that he has given otherwise statement. But in this case, he has
That means Mahajar witnesses have not supported. Yes. Because in the sense that the Mahajar witnesses have not supported the prosecution, and in this, both the courts below have lost sight of this. And both the courts below have lost sight of this aspect. First up, Sri Vishwamurthy, learned government pleader, submits that the recovery of the stolen property was made at the instance of both the accused. Both the accused. The same has been established. In a case of theft, recovery plays an important role. Since the instance of the petitioner, there was recovery of the stolen property. Both the courts below are justified in convicting the petitioner and the other accused. He further submits that the petitioner is involved in another criminal case. For this reason, he is not entitled to claim benefit under the Probation of Offenders Act. Next para. It is to be stated that while this coordinate bench of this court disposed of criminal revision petition 1097 of 2021, did not set aside the conviction. Benefit under the Probation of Offenders Act was extended to accused number 2, finding that he was the first time offender. But the same benefit cannot be given to the petitioner because according to the report submitted by the police inspector of Ajampura police station, the petitioner is involved in another theft case. And he was convicted in that case also. Theft case. He was convicted in that case also. Therefore, the petitioner is not entitled to claim the benefit. Next para. Examined whether there is any good ground to admit this petition, it is found that the stolen property was recovered at the instance of the petitioner and both the accused, at the instance of the accused persons. Full stop. The trial court has held that recovery has been proved in accordance with law. First of that apart, the coordinate bench has already taken view. The criminal revision petition 1097 of 2021 that The conviction recorded by the magistrate and confirmed by the sessions court cannot be set aside. So therefore, no different view can be taken so far as the petitioner is concerned. In this view, there is no merit to admit this petition. Therefore, petition is dismissed. Vinuta P. Kale. Venkat Reddy, 40 adjourned. 41. The counsel for the petitioner is absent. List after 2 weeks.
42. Satish Kumar MP.
Yeah, what is the case? Please tell. This case is listed for admission. What is your case? What is the ground for admission? Huh? Notice is not served. How do you say? How do you say? Where is the finding on that? $36. 36. Postal receipt letter. Huh. Huh. So please read the finding on this. Finding of the magistrate. It is stated that notice was served on 18/8/16. Who say that notice was not served? How do you say? Mere making a deposit does not mean that there is a good case for admission. What is your defense? Between legal notice, Exhibit P6 actually is a intimation given by the post office to the complainant, stating that the article sent under registered post was served. Yes, but sir, not served and then what is yours? No ground to admit.
in the appeal. Case number 23, my lord.
23. Please read.
After he has also denied that the appeal was repaid loan amount within for 3 months. Further, he denied that the 3 months appeal and the rain for him and expressed inability to pay the interest and assure that they will repay the loan amount within 2 months. Further, he denied that he received the check issued by the appeal. Further, he denied that even after service of notice, the appeal approached and assured that she would repay the remaining amount of 38,000. Further, he has stated that he received an amount of 5 lakhs to his share from the sale of family property. He has stated that he has no hurdle to produce the document in respect of sold out of his land. He has admitted that there is a different link between the contents of Exhibit B1 and signature of the Exhibit B1. Further, he denied that the order to make a unlawful change in the check by mentioning an amount of rupees 1,70,000.
Oh, they have just given suggestions. He has denied it. How does it establish your case? Huh? Good. Since the counsel for the petitioner submits that he will try for settlement. Notice is ordered to the respondent. Yeah, 1 of 22 is fine. In suspension of the sentence. The petitioner is sustained, has been convicted for the offense under section 138. Sentenced. 9 of rupees. $1,90,125. 190,125. The default sentence of 6 months simple imprisonment. The trial court has, appellate court has confirmed the judgment of the trial court. Since the petitioner is ready for settlement, till such time settlement comes through. The sentence imposed on the petitioner is suspended, subject to conditions that she shall deposit 50% of the fine amount by deducting the deposit already made. Deducting 20% of deposit already made by her. And execute a bond for rupees 50,000 and provide a surety for like sum to the satisfaction of the magistrate. Balance of deposit shall be made within 4 weeks from today. $45.
I'm applying for petitioner, my lord. Kindly pass over the matter, my lord. Senior is ready for arguments. Kindly pass over to 2:30, my lord.
Time is 12 o'clock. Why can't you argue?
No, because my lord senior is held up in division bench, my lord. So kindly permit on the 230, my lord. Because we have taken the permission from the opposite advocate also, my lord. He was also ready for that at 230, my lord. So kindly permit.
Correct. Yes.
Much obliged, my lord.
Rupesh Kumar.
For the respondent, my lord. Really, they have not been coming. So it's not even a fit case for admission. The check amount is 3 lakh, and the defense is that the check was stolen, and also